if the protection order, Mr. Daniel, if we have domestic violence happening in a family, it has resulted in divorce, you could take that whole divorce matter, and this is for the young attorneys listening as well to learn this. It's possible to take the whole divorce matter and the domestic matter, and you bring any claim where? Before which court?
Right. So that you would have to file before the family court in Port of Spain. Now there are some family high court, but there are some matters that are heard before masters in the family court. So if it's a simple divorce, no children, no property settlement, none of these complicated issues, they tend to put those matters before the masters. Because the masters, yes, they're on the same level as a magistrate, but they have they higher than the magistrate.
Right.
I said the same level to use the example of the magistrate court and the the masters. But when we go into the family court itself, they have the power to grant the divorces, the masters. But if it's a matter of a protection order, if it's a matter of care, custody, control, maintenance, access of minors, the property settlement, those type of matters will go before the judges in the high court.
Yeah.
So in any divorce, you would have your grounds for the divorce. And if your grounds is that of unreasonable behavior and abuse and that stuff, then you can ask one of your reliefs in your divorce pleadings. One of your reliefs could be for protection order against the alleged abuser.
I love it. I love it. Beautiful. And that is really what we're going to be expanding more on, and understanding that if there are victims of domestic violence and or you know someone and they would like to get out of it is a marriage where this is happening and they would like to divorce, as Mr. Daniel would have identified. Well, we're going to go more into that next week when we start and we enter into family law. We're going to start off right off the back, I believe, with divorce. I think so. I'm not sure. I think it's divorce. Right? And one of the release, and now there's only one grounds of divorce, to be one ground and 5 facts. All right. But one of those facts is unreasonable behavior, as Mr. Daniel would have identified. You can ask for the same protection order that we would have identified under the Offense Against the Person Act and under the Domestic Violence Act, and that same protection against the perpetrator can be seen as a relief that you request or you claim for under your divorce. All right. So there are several places where protection orders can happen. And it's important for you as a client to know what you can ask for, or to, have the conversation with your attorney, and or attorneys know how you can, in the best and most efficient manner, give these redress for your clients. You don't want to have them all over the place. Go and get protection order here, and then do this here, and you know what I mean? Utilize properly about the laws to make the most sense for the clients. Mr. Daniel, do you agree?
Yes. Yes.
All right. So you're running right.
Just one thing before you go. If you need an immediate relief or you need an immediate protection order, the family court sometimes is the better route to go, because your attorney could file a certificate of emergency and ask for the matter to be heard as soon as possible, and the next day or the following day you can get a hearing in the family court for if you file the divorce and you ask for the protection order. If the court is satisfied that your claims on your alleged claims is so serious in nature and you are really at risk, then the court would accept the certificate of emergency and schedule a hearing for you within the coming days. The magistrate court, you may not get that rapid response and that immediate relief.
I love that.
So you see the attorney and you really weigh your options as to where you would make this application.
Yeah, I love that point, because I remember we were talking about when we used to have our radio programs, and we were talking about the fact that because of the nature of the family court, it honestly is almost kind of social. It is designed and set up not just to administrate law, to administer justice. It really is to mitigate problems that occur in a domestic environment and in a family. And they are very responsive and reactive to getting relief for claimants or petitioners. When you petition the court for redress and help, as Mr. Daniel would have identified, it is a better chance of getting a faster reaction. And we do know the reality of our court culture and our judicial procedure in Trinidad and Tobago. Obviously, it's worse now with COVID. It can take years to do a lot of things, or even months and weeks. But we have seen it is a reputation of the family court to move a lot faster with things because they understand the nature of the matters. All right. So we're seeing some beautiful questions here, and we're going to be answering them as much as possible as we can in this. You see, I make sure take questions exactly 6:30 so that we have enough time, right, to get them in. So let me start from the beginning. Everybody saying good evening, good evening. Yes, evening to all. It is a rainy Monday, and we still came out, and we're grateful for those of you who still, came online and committed to the program. We like that. Remember to share it, all right? Somebody said domestic refers to family, which is father, mother, and kids, extended family and relatives. Shahida, domestic is defined in the act as well. So there are a lot of definitions, and you yourself could download the act and see all legislation, when there are specific words that they require legal definition, you will receive all those definitions in the act itself, all right? So next question. Good day. If a spouse applies for a custody protection order against their partner, how is custody affected? Can the parents still see their child even if a protection order is against them, especially if the terms of the protection order does not include the child? Very good question. Mr. Daniel, how do you so answer?
Right. So the protection order does not include the child. Very important here. The terms of the protection order would also be important here. Now, if the terms of the protection order is to stay 30 feet away and not to come in any contact at all with the spouse who has the child, then a third party, a trusted party, and the court would ask, well, who is a party in common? The grandmother of the mother, the mother of the mother, which is the grandmother of the child, the mother of the father, the grandparents, an aunt, an uncle. Who's a trusted person who could do the picking up, the dropping off, the meeting, the facilitating, the kind of access to the child. Now, custody and access is two separate
things. Yes.
The family lecture. So in custody, I'm not sure if access is meant in question, but I'll touch on it both. So in custody, if you know everything you state on your particulars is alleged. It's alleged that he would have used physical abuse. He slapped me, he broke my hand, he cursed, he said, I burn down this house, I'll kill you if you go with any other man. Those things are alleged. Now, if you prove those things to be true, and he never once threatened the child, because you are saying that the child is not included in protection order. He never once abused the child, he never once used obscene, threatening language towards the child. Then the court is not going to make any orders against him in relation to custody of the child.
Right.
Now, custody of the child, yes, you may want to prove that his behavior towards you is inhumane, it's very abusive, and that kind of thing. But to really use that to shift it towards how we would treat his child is a far of a stretch. Now, if you have evidence to show that he's abusive towards his child, physically and verbally, then that certainly would affect the custody, because the welfare of the child is the most important for custody. Now, if you have that, it will affect the custody. If you don't have that, then you have a fair chance for custody. For access, if parents have the mother, let's say, has a protection order against the father is not to use obscene, the normal thing, not to come within 50 meters of her. The court is going to ask for a trusted person to facilitate. If the father comes to pick up the child, the mother cannot come out with the child, because then you're going to breach the protection order. So who else stays in the house? Is a trusted person, and they would facilitate the transfer. So even though there's a protection order, it doesn't stop. Now, if there's no 50 feet and no stay away, then it doesn't stop the parties, and that's something that's commonly confused. A protection order doesn't say I cannot talk to my wife while beating every day, you know. The protection order doesn't say that. Protection order says do not use obscene language, do not use threatening language,